Hello, everybody. My name is Bill O'Leary, and I am coming to you live to talk about an estate planning topic. I'm an estate planning attorney with Legacy Planning Law Group in Jacksonville, Florida, and I'm coming to you live as part of a weekly series that I do, at least most weeks, where I talk about a different topic that I run across or maybe I'm asked about. We call this weekly series our Thirsty Thursday. So if you're thirsting for knowledge and for information, you come to the right place. What I want to talk about today, it actually came up in a conversation last week, do it yourself estate planning, DIY. Well, I want to talk about the hazards of do it yourself estate planning. There are a number of websites out there that are customized, what are called do it yourself wills and other estate planning documents. And yes, although these online products are convenient, using them could very well create very serious legal problems, expensive legal problems for your heirs. These online or digital services, well, at first blush, they might appear to offer, very cost-effective and easy alternative to visiting an estate planning or elder law attorney. But the question you should ask yourself is this: is online estate planning worth the convenience and the initial savings? While these online services, well, they might work fine if maybe you have little or no property, or maybe you have just a small amount of savings, a small little investment. And if you have a more traditional family structure or family tree, uh, it may work fine. But anyone with more complex needs should not try to create an estate plan without the help of an attorney. So what does complex mean? What defines a complex need? How about minor children? Well, the online products that you get will not do a good job of setting up a trust, let's say for children, to avoid having to set up or pursue a guardianship legal case. Or what if you want to protect the inheritance that you want to give to your adult children, so that inheritance doesn't leave the family bloodline in case your adult child gets a divorce or in a liability situation like a car accident? Or what if you are in a second marriage and one or both of you has children from a prior marriage, what we call blended families? Using an online product, frankly, would be a disaster. I wanted to share with you just a few tidbit stories, true stories, examples of how online generic wills can create big problems for loved ones. So the first story actually occurred here in Florida. And so there was a woman here in Florida that used an online will, a very generic will, listed several possessions in a bank account that she intended to go to her brother. Now, after writing up the will, the woman actually came into some additional money. She inherited some additional money and property. However, the online will that she put together did not have what we call a residuary clause. And what a residuary clause says is who gets the estate after specific gifts are made, maybe a specific gift of this account or this car to this person. Anything that's left in the estate, where is it going? Who's getting it? Seems like a fairly sort of fundamental basic point. But her will did not include this residuary clause. And so she bothered never to revise the will after she had inherited this additional money. She never added a residuary clause. Well, after she died, her brother argued that he should be entitled to all of the deceased person's estate, including those assets that she inherited after doing the will. But lo and behold, the woman's nieces come in and argue, well, no, the estate should pass as if the woman died without a will, what we call intestate. Well, the case went through the courts, wound its way all the way to the Florida Supreme Court that made a ruling in 2014 that because the will had no residuary clause, that where the residuary clause would sort of include or pick up the money that was inherited after the will was done, since it lacked that very fundamental type of legal provision, then the woman's assets would pass under Florida's laws of intestacy. Again, intestacy, dying without a will. And what that meant was the result was that the brother was not the sole beneficiary, as I think was intended by the deceased woman. So the lesson to be learned, the online will lacked a very basic legal clause, a residuary clause, huge mistake, and frankly, no excuse at all for it not to be there. The online provider really botched it. Case in Massachusetts, a man used a prepackaged will form to leave his home to his wife and his 4 grown children from an earlier marriage. The problem was that the will didn't give his wife the option to remain in the house, live in the house for the rest of her life, which she intended. So a court case ensued after death because the children, who, by the way, possessed the majority interest in the property, frankly, they wanted to kick the wife out. Then there was a case in Pennsylvania, this was in 2012, not too long ago, where a man wanted his pickup truck to go to his daughter and the summer house to go to his son. Well, he also wrote in the will that he was intentionally leaving out the other 3 children. So he's just including 2 children, leaving out the other 3. The problem was the man did not specify what to do with the remainder of his estate. So he died, leaving an estate worth, according to the court records, $217,000. And, he probably intended for that money to go to just the 2 children, but not the 3 children that he was disinheriting. But because the will had no residuary clause again, the remainder of the man's estate passed under the state law that specifies who's going to get the estate if there's no will in place at all, what's called the law of intestacy. So what that meant was that the estate was divided between all 5 children, even the 3 that the deceased man did not want to include, certainly not what he had intended. And the last thing I will mention to you, so there's a very, very large online seller of sort of do-it-yourself wills, whose name will go unmentioned, but you've certainly heard of them. And what they had to do was not too long ago settle a class action lawsuit brought by an unhappy customer. And in that case, a niece had helped her uncle prepare a will and prepare a trust using that online tool. The niece, you see, believed that the documents that they created would be legally binding. And if they had encountered any problems, well, all that she'd have to do is call that company's customer service department, who would help resolve them. The niece, what ended up happening was, after doing that online trust, she was unable to transfer any of the uncle's assets into the trust because the financial institutions that held his money, why? They refused to accept that online trust document. They said it's no good. And so they refused to accept it as being valid. And so she had to hire an estate planning attorney to fix the problems. And so that attorney also discovered that the online will had not been properly witnessed, to add insult to injury. All of this cost the uncle's estate thousands of dollars. So the irony here is that using these boilerplate online forms, if you will, not only frustrated the deceased person's intent in these cases I mentioned, but ultimately cost the estate and the family far more than a simple consultation with an estate planning attorney would have cost. If you'd like to know a little bit more about the hazards of do-it-yourself estate planning and maybe how we can help, we'd love to talk to you. So we invite you to schedule a free 15-minute discovery phone call with our team. You can either go to our website, Legacy Planning Law Group, and there's a book your free call button on our homepage and some of the back pages as well. It takes you to our booking calendar. Or if you're seeing this video on YouTube, go ahead and click the link that's appearing at the bottom. A pop-up now takes you to the same booking calendar. Pick a day and time that works for you. Again, that discovery call is complimentary. If you've enjoyed this video, I ask that you would like it, better yet, share it with your friends, and do subscribe. Speaking of YouTube, subscribe to our YouTube channel. So, hope you've enjoyed this talk about the hazards of do-it-yourself estate planning. I'm going to give another talk next Thursday at about the same time, part of our Thirsty Thursday series. So if you're thirsting for knowledge, we'll quench your thirst. I'm going to sign off for now. Bill O'Leary, go make it a great day and a better one.